Okay, Mr. Falstead, if you're ready to go.
Okay. Can you hear me?
Yes, sir, we can.
All right, good. Yes, I represent the appellant, Aaron DeLon. The single issue on appeal is the double jeopardy argument, the contention that his criminal act could only support one count of attempted manslaughter. And the criminal act was the firing of 2 shots into a moving vehicle occupied
Mr. Falstead, excuse me for a moment. Do you want to reserve some rebuttal time?
Oh, yes, I'd like to reserve 5 minutes.
Very well.
Thank you. And as we discuss in the briefs, it's really a matter of statutory interpretation. In this case, interpretation of the attempt statute. And, you know, a lot of the time the case law looks at what's called the any test, reference to, you know, a person or any person. And I would just note, I actually noticed this after the briefing, so it's not in the brief, but I would just start, well, I do discuss the attempt statute 774.04, and it references in part attempts to commit an offense prohibited by law, and in such an attempt does any act. So the triggering, some of the case law referenced the triggering act for the crime. And here the triggering act is any act towards committing the attempted offense. And so starting with the any test favors the appellant. That's an indication there of some ambiguity. But of course, as we discussed in the briefs, the courts do not mechanically stop at any. They go beyond to look at the entire statute and the focus.
Mr. Falstead, you've made a very compelling argument about the attempt manslaughter being action focused versus victim focused, and has distinguished it from assault, for example, which would be victim focused instead of action focused. But we have a decision, Scott versus State. I know you're aware of it because it was in the briefs, and you've distinguished it by saying that double jeopardy was not raised, and because it dealt with really the stacking of 9 sentences as opposed to this double jeopardy issue. But the analysis is right on point for this issue, even though Scott may not have addressed it. And I'm sure you're reminded that our court affirmed convictions of a defendant who sprayed automatic weapons fire at 9 people in a single episode and was found guilty by a jury of 9 counts of attempted second-degree murder. So the analysis, they may not have specifically taken on the double jeopardy issue, but that analysis certainly is overwhelmingly compelling for us in a case that we are bound to follow. So you want to help me understand how we can avoid Scott?
Well, yes, well, of course, as a threshold issue, it's a settled, the appellant effectively concedes that he can be convicted of multiple counts. Multiple counts do permit consecutive sentences in the absence of some prohibition. So I would submit that a sentencing issue is very different from whether
There's no question about that. And you've made that argument. And that's why I pointed out that I already know you've made that argument, but it's the rationale in this case. I mean, here you're saying he can't be convicted of 4 attempted manslaughters because he can only be, he only did 1 act, 1 episode. You have almost the same facts in Scott. You have one guy spraying bullets at a crowd of 9 people, and he gets convicted and sentenced of 9 separate counts. And again, it's not a double jeopardy case, but it's the same analysis, same kind of facts. It really lines up with this case almost completely. So it's a very compelling case for us to want to follow.
Well, I would begin by suggesting that if the issue I'm raising had been specifically raised in Scott, the court perhaps would have
we'd be stuck, right?
Well,
we'd have to follow it. Yeah, and I realize it's distinguishable, but the analysis is hard to distinguish.
Well, For one thing, well, I would note if the appellant in Scott had raised the point, the court very possibly would have reversed on the basis of the argument I've made, reversed the multiple convictions. You wouldn't reach the sentencing point. But aside from that, since we do have it, I note that the Scott case makes a reference of multiple victims, and you don't.
Well, you got 4 here. They had 9. Right?
Well, yes.
Mom, dad, 2 children, 4.
You've got it asserted. Well, they're identified as victims. They're I guess I'm kind of dealing with a hypothetical circumstance where I'm thinking the court maybe would have reversed the multiple convictions if it had been raised. You take it as a given that you've got multiple victims in the Scott case because that wasn't disputed. I would submit that in this case, you don't have victims in the sense that that term is usually used, because in, well, what I would call victim-oriented cases or victim-centered crimes where you do allow multiple convictions, you've got identified victims, but the victims are typically identified because they suffered some harm that was intended to be addressed by the statute. It was an element of the offense that for assault, the victim was placed in fear. For battery.
Well, in this case, your argument is, had the manslaughters, God forbid, been carried out and completed, you wouldn't be making this argument. You've made the argument because it's an attempt. It's the action that's the focus, not the victims. Yet, there's controlling authority to the contrary that says an attempt should be viewed just like the completed act for this purpose. Right? I mean, so simply because the act was not successful, it becomes an action-based focus as opposed to a victim-based focus.
Well,
that's your argument, is it not? Isn't that your argument?
Well, yes, it is my argument, because attempt is really focused on what could have happened but did not happen, whereas the victim-focused offense is concerned with what did happen.
So the completed act then should be treated differently for this purposes than the effort to complete the act, which was not successful. That's your argument?
Yes, that is my argument.
Does that, I mean, that seems illogical to me. And there's, authority to the contrary that doesn't support that. I mean, I have a hard time understanding just because a person wasn't successful that it's no longer victim focused, but had they been successful, everybody agrees it'd be a victim focused criminal episode.
Well, with the attempt, it's just much more difficult to, well, I guess, rein in the boundaries of who is the victim and how many counts there could be. With the resisting an officer, you've got, if there were 10 or 20 officers, would there be 10 or 20 counts? And, if somebody fires a gun into a room of 30 people and doesn't hit anyone, is it 30 counts of attempted murder or attempted manslaughter? With attempt, you don't have that tangible consequence that you have with the completed offense. And I would just note that there is a kind of symmetry here. I suppose there's a suggestion this might lead to absurd results, but it really does not, because if the attempt causes harm to people, you've got the person who attempted an offense can be convicted of other offenses based on the consequences of his action. In this case, the appellant was convicted of 2 other offenses, firing into a vehicle, firing within 1,000 feet of people. And so if the bullet had hit someone, you would be talking about perhaps aggravated battery. And so you've got this symmetry where you can carry out the legislative overall intent of holding people responsible for what they did, and also with attempt what they tried to do, because if the attempted offense causes harm to people, that's going to be the subject of additional charges. So you've got the whole criminal episode covered by the applicable charges. And I guess the concern with it, transplanting manslaughter or any completed victim-oriented offense over to the offenses, you don't have that limiting principle of figuring out who the victims might be, because with the completed offense, you look at who was harmed, there's your guide. And if if the appellant in this case shot at a bus and with 30 people aboard, I would suggest it would be untenable, somewhat unreasonable that he faces 30 counts of attempted murder.
But we don't have these facts here. What we have is he shot 2 times from a motorcycle into a van or a SUV with a mom and dad and 2 children in it. So the victims are clearly identified.
Well, I would suggest but the universe of victims is actually potentially larger, as I noted.
Well, I know you made that argument, but it's not very persuasive because the bullets went into the van.
Mm-hmm.
And the 4 people were in the van. And there's always collateral possible consequences in any action like this, but these were 4 very clearly identified victims based on the facts of this case.
Well, I would note that manslaughter really doesn't have an intent requirement. So you don't, with attempted manslaughter, you don't really focus on who he might have been attempting to harm, because manslaughter doesn't require any attempt to harm anyone. It simply requires the committing some egregious act that caused a death. And so I would say that, again, it's just difficult to rein in the concept of who the victims are and where you expand the counts, multiple counts of criminal responsibility. And I would also note that the attempt statute, it addresses the entire universe of offenses, all kinds of offenses. There are act-centered versus victim-centered offenses that can be attempted. There's, I believe that there can be an attempted introduction of contraband into a jail or a prison. There's, you can have attempted sale of drugs.
And if we had one of those, your argument would be more persuasive. But we don't have that.
Well, no, we don't, but we have an extremely broad statute, the attempt statute, and the attempt statute really doesn't differentiate between different types of attempted offenses. And I would just note that the legislature, when the legislature,
and that's precisely, sir, why the focus on attempt is what was the act, what was the offense that was being attempted. And that's why you have to look to the offense itself, not the attempt statute. And so in situations where you're attempting, an offense that requires no victim, your argument's a good one. If you're attempting an offense where there are victims, such as manslaughter, I have a harder time with it.
Mm-hmm. Well, I guess I would fall back on my point that you, with the completed offense of manslaughter and other victim-oriented offenses, you got this very clear guide as to how many counts someone is guilty of, because you've got the harm that is identified as an element of the offense. And you don't have that with the attempt statute. And I would note that a defendant is not necessarily getting a windfall, because he's going to face charges for other crimes besides the offense based on whatever harm he's caused or whatever other laws he violated. If he shoots at a vehicle and causes the vehicle to wreck or hits someone inside the vehicle, there's more charges based on the damage that this act did. And that could be piled onto the attempted manslaughter or attempted murder. So again, there is a kind of symmetry between my interpretation of the attempt statute and the limited reading of the attempt statute I argue for, and the more broad reading of all the other offenses the defendant is guilty of for the harm that he caused. for his attempt. Interestingly, attempt does not require any actual harm to occur. Actual harm is not an element, and the harm caused is as I say, it's an important principle in figuring out just how many counts he might be guilty of, and that harm is absent from the attempt statute. But then the harm caused in the attempt, someone who is hit by a bullet, that can be covered by multiple other charges.
Mr. Falstead, excuse me a moment. You're up to 15 minutes, and I know you wanted to reserve 5, so proceed as you wish. It's your time.
I will at this time reserve the rest of my time unless the court has further questions.
Thank you, sir.
Thank you.
Ms. Taylor.
Thank you, Your Honor. Excuse me, may it please the court, Cerise Taylor on behalf of the state of Florida. Your Honors, the allowable unit of prosecution in this case is tied to the manslaughter by act crime. And because of the individualistic nature of homicide offenses, which manslaughter falls under, we look to the individual victims, the people, the human beings involved as the object of the criminal act, not the criminal act itself. And really, we cannot parse the attempt statute from the manslaughter by act statute. When we're looking at an allowable unit of prosecution analysis, that's really the beginning. The legislation language directs what the unit of prosecution is going to be. And when you look at the manslaughter by act language, this is language that hasn't changed since 1892. It's a killing of a human being. And under the A&E analysis, right up front, we see that the individualistic nature of the language, whether or not we had a history of homicide offenses being personal, the legislature attempting to protect human beings, we see this language is telling us that manslaughter is an individualistic crime. And that result cannot be separated away when the crime is not completed.
Mr. Falstead's made a pretty interesting argument that the attempt, as distinguished from assault, for example, assault requires a victim, a putting in fear, that sort of a thing. Attempt does not. You can be guilty of attempt if you tried to do something and nobody knew it, right? So his position is, that being the case, there are no victims here, because in theory, you can be charged with attempt, convicted of attempt, sentenced for attempt for something that no victim even knew you were trying to do to them. So it says it's separate. This is an action offense as opposed to a victim offense, even though the completed act would be a victim-centered offense.
A couple of things I'd like to respond to about that, Your Honor. Obviously, this is not an assault case, so we don't have the same criminal elements as we do in assault. We don't have a putting in fear as a necessary element of the manslaughter, or indeed of the original charged crime, which was second-degree murder, attempted second-degree murder. So we're not really looking at the victim's point of view. But more importantly, just going back to the statutory language, because when the court considers the definition of the crime of attempt, you're attempting to commit an offense prohibited by law. And so, yes, it uses the "and" language, "an offense," meaning a singular event, but prohibited by law directly connects that attempt back to the index offense, if you will, the genesis of the crime. Attempt cannot exist in a vacuum.
So our analysis here has to be, what did the legislature mean by these words, right? That's our job here, to figure out what they meant. Not whether we think it was a good idea or a bad idea, but what did they mean? Because that's what we're trying to do, is be true to what they meant. So your suggestion is the choice of those language somehow indicates that an attempt is victim focused.
An attempt is victim focused when the crime attempted is victim focused. And that's how we get away from the chaos that is suggested by Appellant's argument, is that we know what direction to go in because we look at the originating offense. What is a defendant attempting to do? And when we look at what the defendant is attempting to do, that's how we know, is it an act-based or it is victim-based? And this analysis can be really successfully applied because we do see cases where, admittedly completed offenses, where we're looking at the statutory language to tell us what is the legislature intent. And in all of these cases where the crux of the case is a homicide-based case, whether it is, and really Bautista is a good example of this, because Bautista has DUI manslaughter, and the statute in that case does not say a human being. And so we've got that any language in Bautista. And so the Florida Supreme Court was, well, looking at what do we do now? We've got this language, we've developed this any test, and we've said this is the test that applies. What do we do in this case when we know that there were deaths, multiple deaths? And what the court concluded is that DUI manslaughter is not a DUI crime. It's a manslaughter crime. It's a homicide crime. And because of that, despite the fact that there was that any language, the court is still going to be guided by the overall legislative intent to protect human beings. I would submit that the same analysis applies in this case. Attempted manslaughter.
Well, except for in Bautista, tragically, we have a victim, right? We don't have
multiple victims, right?
Right. Somebody died in Bautista. Nobody was hurt here. So
that is correct.
And Mr. Falstad seems to have focused his argument on attempt is focused on the act, not on the victim. And that's the only reason Bautista may not be a perfect crossover, because you actually have a victim there.
Well, I agree with Your Honor that we do have a victim in Bautista. The reason that the state relies on the Bautista analysis is to establish that the court can look beyond plain language to find what is the legislative intent, the crux of the case. And in Bautista, they found it was protection of human beings, manslaughter. And that's why it was human focused. And similarly in this case, even though there wasn't, fortunately, any injuries or any deaths, the crux of this case is not attempt in a vacuum. It's attempt to commit an offense, that offense being manslaughter. And so if attempt, it can't exist by itself. It is inextricably linked to that which is being attempted. Just like the definition of manslaughter is the killing of a human being, that clause of a human being necessarily modifies the verb, the killing. Similarly, the attempt cannot be parsed from that which is being attempted. And so that's why we rely on Bautista, just to point out that the court can look at what is the ultimate harm. And that's what made the Bautista court conclude that the harm was not the DUI act, it was the manslaughter, the death, the human being. And the legislative intent to protect human beings, that is reflected all across the board in homicide-based cases, would be unraveled if the person who attempted to kill a human being but was unsuccessful had the entire focus of the legislative intent and why the legislature drafted the statute removed, leading to the potential that someone could spray a room or a vehicle with multiple bullets and potentially kill and endanger many members of the citizenry, and yet stand accused of a single offense because of the act. It makes a lot of sense to look at the attempt as it relates to the index crime, the main offense, to determine what the legislature intended. And even just on the plain language, when you look at the unit of prosecution analysis, starting with the plain language, I think we get there. And then if we go beyond that and we look at rules of statutory construction, the whole idea of the manslaughter as part of the homicide offenses, the legislature's intent to punish multiple offenses, even if they arise in the same series of events, is also established when we look at, this is not a Blockberger case, but when you look at the statutes in Blockberger, in the rules of statutory construction that are codified in the statutes talking about Blockberger, they say this is our legislative intent to punish multiple offenses. And so when we have a crime that is victim-centered and an individual commits a criminal act directed at victims, like we do in this case, the victim center has to be what is considered when looking at how we criminalize or how we punish the criminal actions of a defendant. And that is the reason that the state would submit to this court that the attempt statute cannot be considered in isolation and must be considered part and parcel of the attempt to commit manslaughter. I really feel like I've made my point, the state's point. I would be welcome to answer any questions, but if the court has none, I will conclude my remarks and say that the state would ask this court respectfully to affirm the convictions, the 4 convictions for the 4 victims in this case, the Tirado family, and the sentence as well in this case.
Thank you, Ms. Taylor. Mr. Falstad, 5 minutes.
Yes, thank you, Judge. Let me look at note the time. Well, I would note that, let's see, looking at my notes. Well, the state makes the point for attempted manslaughter, you look at the human beings involved, but that's, as I've already stated, that's a bit of a nebulous concept because people involved could have been other people in other vehicles around this vehicle. And I would suggest that in some cases, actually with attempted manslaughter, the notion of attempted manslaughter, I guess you might say attempt, is something of a legal fiction, a permissible legal fiction, because when we hear that someone is attempting something, we tend to think the usual understanding of that term is that he intended some outcome to occur, but manslaughter and attempted manslaughter doesn't actually require an intent for any outcome to occur. The jury instruction says he has to intend the act, but he doesn't actually have to intend for his act to be harmful. It's sufficient that objectively the act was so dangerous that he's criminally responsible for the consequences. With attempt, you don't have consequences to measure. So it's a little harder to cabin in. And looking back at the Scott versus State case that the court asked me about, that's a rather involved discussion of the time and place test. And it seems to relate perhaps more to the contingent issue I raised. In my brief, I've referenced whether, if you agree with me on the threshold point, then you get into whether 2 shots could support 2 counts versus 1 count. And Scott seems to relate more to that, whether there's some analysis for separating different acts in a single episode. And now the number of victims was referenced in there, but you also have discussions about, well, it depends on whether the firearm was fired or not. So Scott seems to relate back to more of my contingent second issue, two shots versus 1 shot. And further, of course, Scott is distinguishable because the issue I'm raising was just not an issue in that case. And when you agree that if you decide multiple counts are permissible, because in Scott it was never questioned, so it's conceded, then you're into sentencing for the multiple counts, which is completely different from whether you can have multiple counts in the first place. So again, you have that interesting discussion in Scott about the evolution of the law having to do with whether the gun was fired. They talk about, well, multiple people could suffer injury in that case, in the Scott case, but well, injury is something that was conceded in that case, you might say, because the multiple counts was never disputed, and injury is disputed in my case because injury is not an element. And in fact, if there had been injury, there'd be more charges accounting for that injury, more charges in addition to the attempted manslaughter. So the Scott case really delves into something that issues, ultimately sentencing issues that go beyond the issue in this case, because the issue in this case was conceded. And I'll leave it at that. I believe I've exhausted my time. I think the court understands my arguments. Thank you.
Thank you, Mr. Falstad. Thank you both. You can exit the our
Yes.
virtual courtroom.